Howdy guys, so we're going to be going a little bit early on this video. Instead of starting right at 12:45, we're going to start at 12:40, and here's the reason why. This particular video is going to go over a topic that introduces a lot of legal theories and a lot of legal ideas. We're going to go through, specifically going through the doctrines of the Whelan v. McMullen 2018 case. And this is after it went through its appeals and everything. And we're going to go through and do a video that I originally wanted to do on this type of channel 10 years ago, but I couldn't. And the reason why is normally when I make these videos, they are just too high up on the education path to be able to understand everything. I'm going to go through paragraph by paragraph and explain to you when it is constitutional and when it is not constitutional for an individual to go ahead and search your home, when you are disabled. And here's what this all comes down to. When does the Commissioner of the Social Security Administration have the right to send somebody with a badge to enter your home, take video, take photographs, take audio, and go ahead and basically search through your premises? What is a search? Is it where somebody is allowed in and they're just looking around but not actually opening things? Is it something where, they're physically turning every item over, pulling out every drawer in your house? Where is the line? So we're going to be addressing specifically in this video high-level legal doctrines. I'm going to go through it slowly. We're only doing one video today. Normally we might do 2 videos, 3, but we're not doing that. Today we're only doing one video, and it is essentially, where is the line for the Social Security Administration's commissioner to send out an officer to search your house to see if you are frauding the SSA. Remember, there's those 3 levels. There's administrative review, where they can send out a cop. There's civil review, where they can send out a cop. And there's criminal review, where they can send out a cop. Okay? The ultimate danger of this is that you could be, with on disability benefits, if they find fraud, either jailed, financially restricted, where they take money from you, or they take away your benefits. Those are the 3 main options as to how they can punish you. So it's pretty important. And it's important because they're very likely to continue to increase, as they are, the amount of CDR reviews that they do. This instance is only for those who are on disability benefits and supplemental security income benefits and disabled adult child benefits, and basically any little auxiliary things that could be tied to directly requiring a severity of impairment standard, where you're medically, whether it's mental, physical, or blind, limited. Okay. As we go through this, if you're not sure of something, I will try to watch the chat section on the right side of the computer. But just as a heads up, it's all the way over here. That's why I can't always see it too well, because the camera's here, the microphone's here, the computer is here with me on it, and then basically, and I'll slide the screen over as much as I can, all the way over here is the chat section. So what I'm going to do is I'll do the best that I can to see what chats are coming in, but keep in mind, these are difficult legal constructs. Okay. All right. Let's go through this real quick. Whelan v. McMullen. Whelan was the disabled person that the SSA investigated because the SSA felt that Whelan lied when she made the statement that she needed a wheelchair, an ambulatory device. McMullen is the cop, the officer with badge that was sent out by the SSA's CDI unit under the authority of OIG, which are the attorneys on behalf of the SSA Commissioner, Commissioner Kijakazi. Although at this point, this was before Commissioner Kijakazi. This is 2018, so this is Trump-era Commissioner Saul. Actually, no, my apologies. This happened all the way back to 2012, which would have been Obama. So that would have been Obama's commission. There were, multiple commissioners back then, but this was an Obama-era search that was then fought in lawsuit and appeal into the Trump era. Okay. All right. So bottom line is, when can a police officer, a cop, a sheriff, somebody hired on behalf of the federal government at the state level, enter your house to see if you have a wheelchair and to see if the armrests have dimples in them from your arms constantly using them? See if there's any stains on it to make sure you're using it consistently and on a regular basis. That's what we're talking about here. That's the level of review that they're looking for. Okay, we're going to give you the intro paragraph. While investigating Kathleen Whalen for fraud related to her application for Social Security benefits, Washington State Patrol Officer John McMullen gained both her cooperation and entrance into her home by requesting her assistance in a fictitious criminal investigation. They use that. Cops use what's called a ruse. A ruse is where they use your trust in the government and your civic duty to help the government, whether it's state or federal. They lie to you. The government lies to you through its officer, its cop, its police officer, and then basically convince you that you can help them. All the while, they're investigating you in actuality, which sounds highly unconstitutional, but in some instances, it is allowed for the government to lie to you. In fact, there are quite a few instances where the government is required to lie to you as a civilian, which is why, and I always say this to you guys, and the Republicans get it, the Democrats don't, but you always want government to be as small as possible and the benefit to be as big as possible to you, meaning that they give you something, but you are not required to give something in return. What's happened in the most recent decades is that the government gives you very little and then expects from you extremely large things, some of which make you a criminal if you don't follow exactly what they want from you. Let's go through this. During his investigation, McMullen secretly videotaped Whalen both outside and inside her home. No criminal charges were ever lodged against Whalen, but the Washington Disability Determination Services Division of the Washington Department of Social Health and Health Services used those videos at her Social Security hearing, and this is the footage that was surreptitiously filmed inside her home. Surreptitiously, like secretly filmed. Cop had 2 cameras on him. 2 cameras. One of them died after about 45 minutes, I think. All right, let's get into this. Okay. Whalen filed this 42 U.S.C. Section 1983 action for damages and injunctive relief against McMullen and DSHS. The parties both filed cross motions for summary judgment. So both parties said, screw you, you're wrong. Judge, just get rid of this thing. We don't want to, we're right, the other person's wrong. Both of them filed their motions. The district court denied Whalen's motion and granted McMullen's motion. So the district court said, we don't think McMullen did anything wrong in the direct sense of him lying to you as an officer of the police, patrol officer, to ruse you into allowing him into your house under you believing you were doing some civic duty, for him then to view inside your house where specifically your ambulatory devices were, which didn't seem like they were being used on a daily basis because there were towels or blankets on them. And for that reason, we don't feel that it was a violation of your constitutional right. Now, this was a lower court, and lower courts screw things up a lot. And that's because that's kind of like, as lower court, your appellates, your higher court, you get your not as experienced, not as, thought-invoking judges at these lower levels, right? You wouldn't expect the same thing from a traffic judge as you would a Supreme Court justice, whether it be at the state level or the federal level. Okay, you just wouldn't expect that. In this instance, which seems relatively straightforward to me, that judge felt, no, in this instance, the beneficiary was wrong, and that the officer could come in, search your house with 2 video cameras while lying to the person as to the reason why he entered in the first place. Obviously, this is craziness. Okay. District court denied Whalen's motion, the disabled person's motion, and granted McMullen's motion, holding that McMullen was entitled to qualified immunity because as a matter of law, it was not clearly established prior to this incident that McMullen's conduct amounted to a Fourth Amendment violation. So, if you don't know what qualified immunity means, it means that for some reason, you are immune from being wrong in that situation. Okay. And usually with qualified immunity, it's like as for the case in total, as opposed to just a defense to one particular topic. And in this instance, they're saying he had qualified immunity because they hadn't really figured out or structured an approach to how these CDI units would be investigating things. So the courts at higher levels had to go through, okay, how does this normally work with other agencies? Because, with like family stuff, DCF, they'll send people right out there. You got to go ahead and do a house investigation. Otherwise, they're cutting off the benefits, So the district court dismissed Whalen's related state law claims, declined to exercise supplemental jurisdiction. Whalen timely appealed. Whalen said, no. This is an unconstitutional search. I'm a disabled person. He lied to me. Unconstitutional. We continue. Section 1983 provides a tort remedy for persons whose constitutional rights have been violated by state officials acting under color of law. That's under 42 U.S.C. Section 1983. Now, the Supreme Court has held that public officials are immune from suit under this Section 1983, except where the violation should have been apparent to the official because the right at issue was clearly established. Okay. So the real question we're getting at is, had these CDI units, right, these investigators that could potentially go into your house, did that CDI unit person have a clearly established understanding or knowledge that going into somebody's home with 2 secret cameras and recording, whether or not that would be a violation of your ability to have privacy in your domicile where you live? Because, the way it works is houses go to where we live, they have a lot of constitutional protections. We're always supposed to be able to retreat into our home to get away from the government. And so and once again, this is more a Republican versus a Democrat thing. A lot of people don't realize, but the whole idea is that, and here's the thing. I'm not going to go into the politics of it, and this is going to stay away from politics as a video. The whole idea is that with government, you want them to defend you, provide whatever benefit they can to you, but for the most part, stay the hell out of your life. That's the goal. That's what you want. If there's some army coming in to take, over, then you want them to defend you from that. That's why you pay your taxes. If there's, some crisis, you want them to defend you, from that situation. But otherwise, you basically don't want them in your life at all, right? If you have to go onto a disability benefit, you're stuck with them, but you don't want them infringing what you can do on a daily basis. Now, the other side of that, of course, is that you have the new very, very left individuals who prefer government to be a part of every aspect of your life, take over rights that you have, like property rights, speech rights, etc., which unfortunately is it's don't be that person if you can. Please don't. You will lose everything and won't have a way back from it because people like me won't be able to defend you once they get rid of people like me. That's the problem. Okay, the Supreme Court has held that the public officials are immune under this situation when there's, when that officer that goes there doesn't, violate something that's clearly established. So if it's clearly established and they go into the house, they should have known better, then they violate it. Otherwise, they're not violating it. They stated that the qualified immunity is immunity from suit rather than a mere defense to liability. Now, immunity from suit means like the whole suit. You are safe from the whole lawsuit as a state-based person conducting business on behalf of the states and the feds. Not just a mere defense to one particular thing that they come at you with to attack you. Okay. Accordingly, qualified immunity protects officials who routinely make close decisions in the exercise of the broad authority that necessarily is delegated to them. So what they said in that sentence is the states and the feds have broad authority given to them. And they then give this authority to their acting patrol officers and police officers and sheriffs to go and do things, to go and further the interests of the federal government and the state government. That's the whole idea here. That's why cops have so much power. That's why sheriffs have so much power, because there's this immunity option to them, okay, acting within the purpose of their investigation. Accordingly, qualified immunity protects officials who routinely make close decisions in the exercise of the broad authority that necessarily is delegated to them. Qualified immunity protects all but the plainly incompetent and those who knowingly violate the law. So what they're saying here is they have so much immunity, these cops and these sheriffs, that it would take a cop or a sheriff that was plainly incompetent. Like, it was anybody could see that that person was well, not anybody, but almost everybody could see that the person was plainly incompetent. That the person was knowingly, he knew while doing this search that he was breaking or violating the law. We analyze qualified immunity claims by determining whether, one, the facts adduced constitute the violation of a constitutional right, and two, the constitutional right was clearly established at the time of the alleged violation. So one, we know obviously is met because, he went into her home, privacy, Fourth Amendment through 14th Amendment. We know privacy is something that is protected by the Constitution in a huge way. So we know number one is met. Number two, constitutional right was clearly established at the time of the alleged violation. I feel that it was, but they did not. Okay, let's go through why. The question whether an action violated the Constitution is often a difficult one. And both district courts and court of appeals are permitted to exercise their sound discretion in deciding which of the two prongs of the qualified immunity analysis should be addressed first in light of the circumstances in the particular case at hand. So all they said there was that you've got two elements, right? Was a constitutional right violated? And was it a clearly established one at the time that the violation occurred? And all he said in that sentence was, okay, cool. You can go ahead and basically do an analysis of using the first element first or the second element first. You can start with whichever one you want. And then also, because courts come to different decisions as to what's available, they give them some broad authority to figure it out. And then it ultimately ends up at the Supreme Court for the Supreme Court to decide what's going to happen going forward. We review the questions of law at issue here de novo. It's like they're reviewing them new. Okay. Because of the important questions presented in this case, we address both prongs of the qualified immunity analysis. We first discuss whether McMullen's warrantless entry into the disabled person's home under false pretenses, that's where they're saying the cop lied to her about why he was there, whether it was an unreasonable search under the Fourth Amendment, and we then turn to consideration of whether it was clearly established that such an entry was a Fourth Amendment violation. All right, so put another way, they've got to figure out if this was a violation of her right to privacy. And if it was, should that cop have known? Should that police officer, should that patrol officer have known that what he was doing was a violation of her Fourth Amendment rights? Another thing you guys need to know as we continue through this video is that the Fourth Amendment gains the power over these state figures as a result of the 14th Amendment. And the 14th Amendment basically is like everybody's, equal in the eyes of the law. And, everybody has to be treated, equally in that sense with that. And that includes from federal to state and things like that. That was a really crappy explanation on the 14th Amendment, but that's the general idea here, is that the 14th Amendment allows the Fourth Amendment to apply to this police officer. Okay. All right. We turn first to the question as to whether the disabled person's actions, as to whether the officer's actions violated the disabled person's constitutional rights. Whalen does not contest the constitutionality of her encounter with McMullen at her door or outside her home. Okay. Her Fourth Amendment claim is limited to the officer's entry into her home and his observations of areas inside her home not visible from the threshold. Okay, so what they're saying here is that basically the officer, she's not arguing that the officer had a right to basically be, at the front door and maybe see through the door, right, the threshold as to what was going on. What she's arguing is that officer should have never had further entry into her house, and therefore any evidence that's collected from going into her house is unconstitutionally being used against her. It is fruit of the poisonous tree, meaning like he shouldn't have access to it. That fruit that he gained from it is poison. Okay. All right. The Fourth Amendment made applicable to the states through the Due Process Clause of the 14th Amendment. So that was the thing I was just talking about, 14th versus the 4th, and how the 14th allows the 4th to apply here. Instructs that the right of the people to be secure in their persons, this is the Fourth Amendment, Houses, papers, and effects against unreasonable searches and seizures shall not be violated. That's the Fourth Amendment under the U.S. Constitution. Without question, the home is accorded the full range of Fourth Amendment protections. That was Lewis v. the United States. Indeed, at the very core of the Fourth Amendment stand the right of a man to retreat into his own home and there be free from unreasonable government intrusion. With exceptions, the question whether a warrantless search of a home is reasonable and hence constitutional must be answered no. That was Kylo v. United States. Okay. Also, a cute little quote here, referring to the home as the most constitutionally protected place on earth. So just to understand this, right, whether or not an officer can enter your home, the courts have to come at this and say, look, the house where you live, the base fundamental of it is the most constitutionally protected privacy zone on earth to that person. So each person, when they're born, they have certain rights. Where they live, they have the most rights, which is why I'm saddened to see most of America turning into basically a place that's mostly just rentals. And even then, a lot of people are so poor now as a result of this mismanagement of finances and inflation that many of them are having to sleep on couches at friends' places. So what I'm seeing is that there's an erosion of people's rights to say police officers cannot enter. Because if the owner of that house says, hey, you can enter, but then the person who's sitting there on the couch and the person is there to go ahead and see if that person on the couch is as disabled as they claim they are, well, they don't have all the same protections and rights that they would if they had a threshold and their own home, or at least rented their own home. They're close, but not the same. So I'm sad to see America moving away from the protection of the disabled through disabled being able to afford basically a place to stay. So that's another problem. Okay. So let's go through this basic thing here. A Fourth Amendment search occurs when a government agent obtains information by physically intruding on a constitutionally protected area. Okay. Or infringes upon a reasonable expectation of privacy. Cool. All right. So what we're going to do now is go through basically what that all means. And I just want to make sure this case goes with that. Yeah. As we have explained following Jones, when the government, that's the claim that was in the past, when the government physically occupies private property, so when that cop enters your house, okay, for the purpose of obtaining information, a Fourth Amendment search occurs regardless whether the intrusion violated any reasonable expectation of privacy. So what they're saying in this is they come in and they're searching for things. It is an unreasonable search, basically, without a warrant or without some probable cause to have to run in there, because they're chasing somebody, to capture them, because in that situation, they can chase after somebody as well. Only where the search did not involve a physical trespass do courts need to consult Katz's reasonable expectation of privacy test. Okay, so there's this test that goes through what's reasonable for a police officer to do, when trying to search your house. Okay. Now, holding that an licensed physical intrusion into the curtilage of a home was a search, we now know that this case falls into that situation because that officer went into that home, took a look around, recorded video. It's a search. Okay. McMullen entered Whalen's home. So the cop entered the disabled woman's home with her permission, which he obtained after he identified himself as law enforcement officer, but misrepresented the purpose of his investigation. So remember, he created a fake legal problem, and she was like, oh, well, I'll help you. That's fine. But he was actually there just to investigate her. That's a ruse. That's where the cop will go ahead and lie to the citizen, hoping that the citizen will feel patriotic and want to help the officer. That's one of the most disgusting things that we have in America as to how these people do their job. Okay. So McMullen entered Whalen's home with her permission. He obtained after he identified himself as a law enforcement officer, but misrepresented the purpose of his investigation. In a physical intrusion case like this one, whether a search occurred depends on whether the investigation took place in a constitutionally protected area and was unlicensed or without consent. Because the interior of a home is unquestionably a constitutionally protected area, our analysis is limited to the second question. The second question was, was there proper consent? So remember, we look at this and say, okay, she gave him consent to enter the home, but now we have to ask, was that proper consent? Because he lied to her to get entrance into the home. And she relied on, basically the fact that he should have been a trustworthy police officer. And, it's now obvious from the news that you don't ever trust the police, ever. Not the sheriffs, not the police, ever. They're required by law at times to lie to you. If somebody's required by law to lie to you, you just never trust them. In fact, the prior video I did where I showed two police officers in the thumbnail, somebody called me and left a message and said, how dare I go ahead and put that video up with that thumbnail because I'm putting police officers in a negative light. My response to that is, well, yeah, when they go and lie to people, relying on people's patriotic sensitivity to love their country, and they betray that with the purpose to investigate that person to see if they're still disabled by entering their home and then taking a bunch of footage of it and then calling that not a search, then yeah, I would definitely say don't trust the police on this one. Okay. McMullen entered Wallen's home with her permission, which he obtained after he identified himself as a law enforcement officer, but misrepresented the purpose of his investigation. In a physical intrusion case like this one, whether a search occurred depends on whether the investigation took place in a constitutionally protected area and, was it an unlicensed or without consent situation. So in determining whether a person consented to an intrusion into her home, we distinguish between undercover, that's an important word here, undercover entries, where a person invites a government agent who is concealing that he is a government agent into her home, and a ruse entry, where a known government agent represents his purpose in seeking entry. All right, so let's go through those because that's important. So there's a distinguished thing here between an undercover entry and a ruse entry. The case here that we're dealing with is a ruse entry. Okay. Whether a person consented to an intrusion into her home, we distinguish between the undercover entry. That's where a person invites a government agent who is concealed. They don't know that that person is a government agent. That's an undercover agent. A ruse situation is where the government agent tells them, and they know because of the badge and the frivolities and fluffies of all the things that are on their shirt and their jacket, and I'm of this rank and I've been serving this many years, this many bars on my shoulder, yada yada yada. So as a result of that, they know in this ruse situation. But in a ruse, the officer will lie to the person about why they're interacting with them to gain their trust, and then abuse that trust by gaining information from this entry that they should not have had to begin with. Okay. The former, being the undercover entity, does not violate the Fourth Amendment as long as the undercover agent does not exceed the scope of his invitation while inside the home. So if a police officer lies to you, but they're undercover, that's sometimes constitutional. But if a police officer is not undercover and lies to you, that is unconstitutional. We don't want police officers lying to people in some instances, others it's legal, where they basically lie to the person and the person relies on that person being a government official, and people thinking, government officials aren't as likely to lie to me. I should trust this person. But the truth is government officials lie quite often. It's very common. I mean, just look at our political structure of all the crimes that have been committed. If you look up the history of every single one of our past presidents, it's bad. And it's amazing how bad it is. And I mean like the stuff they did before office, because, after office, they're getting hit with everything. But before office, it's amazing. I mean, look up the Bushes, look up the Obamas. Trump's going through it right now. Biden will be going through it, whether he gets another 4 terms or whatever. I mean, he'll get hit down the line too, because they've got his son with everything. So, it's one of those situations where to get up that high, you have to be a certain type of person. And to be a certain type of person, you have to be able to, I guess, for at least some time, get away with things that are illegal. That's what it is. That's always how it kind of comes down. But anyway, so let's keep rolling through this. McMullen appealed to Wallen's trust. So the officer appealed to the trust of the disabled person in law enforcement and her sense of civic duty to assist him in his identity theft investigation was clear in this claim. McMullen's description, the cop's description, of an identity theft investigation was perfectly plausible, and Wallen readily agreed to cooperate. But there was no identity theft investigation underway. So what they're saying is the cop made up an identity theft investigation. It was all fake. None of it existed. He just used it to gain the trust of the disabled person. McMullen lied to Whalen about his real purpose to investigate her for possible Social Security fraud. Whalen's consent to McMullen's entry into her home is vitiated by his deception. Okay. So basically it's made like soured by it. It's soured by the deception that was created there. McMullen argues that Whalen's consent, so the cop argued that the disabled person's consent to enter that house should nevertheless be deemed valid. So the cop is saying it still should be allowed. It still should be allowed because she, the disabled person, testified at her deposition that she would have invited Detective McMullen into her home even if she had known he was there investigating her and not identity theft, which is a weak argument. It's a very weak argument. But an answer to a hypothetical deposition question is not consent to a search. And it cannot cure the illegality of the search at issue. It is entirely immaterial that McMullen could have lawfully searched Whalen's home by securing her consent without using a ruse. So what they're saying is, even though Whalen, who basically was the disabled person, even though she said in a deposition, hey, I still would have let him in if I'd known that he was there to investigate me. The court's saying, no. Just because she said that during a deposition doesn't mean that she would have done it when it was going on. Doesn't mean that, this is a situation where, let's call it like it is, where she would have definitively allowed him to enter. This is a question down the line during a deposition. That's not the same scenario, not the same emotions that disabled person is using. And even if it was, it's a hypo that's not acceptable as curing the fact that he entered by lying to that person. The police officer's argument is akin to justifying a warrantless search on the ground that a warrant would have been issued if one had been sought. Regardless of whether Whalen would have consented to McMullen's entry into her home if he had not used a ruse, she did not validly consent here. Okay. So far, this appears to be an easy case like Jardines, which was 569 U.S. claim. A government agent entered into a home to gather evidence without license to do so because he gained consent using a ruse. But McMullen also argues that his entry into Whalen's home was not a search within the meaning of the Fourth Amendment because it was for civil investigation done to determine eligibility for government welfare benefits. He relies on two cases here, Wyman v. James and Sanchez v. County of San Diego. In Wyman, so these are these claims about basically warrantless searches, okay, where they entered the home without a warrant. Wyman, the Supreme Court upheld warrantless home visits by caseworkers as a condition of receiving benefits from New York's Aid to Families with Dependent Children program, AFDC. Okay, so basically, in order for you to get money, you have kids. The kids are young. You need money to be able to survive for whatever reason. Most of these things turn out to be a young female who had kids from a male. The male is a deadbeat dad, and as a result of that, she's got to get help from a DCF kind of spiel, like some group that basically can pay her money to be able to survive, feed the children, etc. Okay, which is unfortunately, and another thing that's unfortunate is that in America we are seeing a massive uptick in these deadbeat dad situations where you have just a guy who gets somebody pregnant and then is not capable of paying for that child. So DCF has to step in, and hundreds and hundreds of thousands of dollars have to be put into the hands of somebody who hasn't necessarily worked for them, but is in a life or death situation because she now has very little money and a child to feed, and in many instances more than one child, and it's a difficult situation. So Okay, now under New York law, public assistance to families with minor children required periodic home visits to ensure that the child's physical, mental, and moral well-being are safeguarded and that the welfare of the child was not endangered. Okay, and that makes sense, right? You want DCF to check in, make sure the child's doing okay, make sure the parent isn't just buying drugs with the money or something, terribly horrible like that. There was no criminal penalty for refusing the home visit, so they could refuse them at any point. However, and they could be scheduled in advance. But if a beneficiary did not consent, right, somebody getting these, child benefits, right, the visit would not occur and welfare benefits would be denied and discontinued. The court reached alternative conclusions. First, it concluded that the visits did not rise to the level of a search in the traditional criminal law context, noting that the visits were not forced or compelled. Nobody forced these visits on that person. The only thing is, if you don't do the visits from DCF or one of these like family, AFDC groups, then your welfare benefits are cut off. And for a single mom, that's obviously a bad deal, but they're not forced, right? There's no knife to the neck, gun to the head of this parent in that situation. Okay. Second, the court held that even if the caseworker's visit was considered a search in the traditional sense, the visit was not unreasonable and therefore did not violate the Fourth Amendment. So they're saying that, yeah, obviously it's a search to see if the kid's okay, but we're going to allow it because little kids can't take care of themselves. That's why child predators are extra horrible. That's why we don't allow child porn, and it's extremely illegal, and it should never be allowed to be legal. Even though California keeps trying to do things about making things legal for those who have that kind of material, which is absolutely unthinkable. I don't know how California is getting away with that extreme way that they're going. And they're trying to also change preference allowances so that people would not be arrested for having that content in general, let alone then the discussion becomes their distribution of it. So, but again, because they're kids, we allow a bit of a Fourth Amendment sidestep because we want a government agency to take a look at a parent who can't afford the children that she's got to get a benefit for. And that makes sense. Think about it. Is this parent usually working? Very little or not at all. Because if they're working, they got to get a babysitter. If they don't have a babysitter, like a mom or something, they can't afford one. They can't afford somebody to hang out there and watch the kid. So they pay the parent, but because the parent doesn't fall in line with the traditional going to work, understanding the sense of working and being around others, how to appropriately interact, because that parent doesn't have that skill, that training from being in the work environment, they step in and say, we're going to make sure the kid's okay and the money we're just giving you is being used properly. It makes sense. It's the way it is. All right? There was no criminal penalty for refusing the home visit, but of course, if you don't do it, they take away the benefits. The court reached alternate conclusions. First, it concluded that the visits did not rise to the level of a search in the traditional criminal law context, noting that the visits were not forced or compelled. Second, the court held that even if the caseworker's visit was considered a search in a traditional sense, the visit was not unreasonable and therefore did not violate the Fourth Amendment. The court explained in some detail why AFDC's home visits were not unreasonable searches. Among other things, it emphasized that AFDC scheduled the visits in advance at a time convenient to the recipient. So basically, the mom with the kid that was getting benefits got a scheduled, hey, we're going to come in this time or around this time. And then as a result of that, it wasn't an unreasonable search because the person knew, like, they're coming on this day around this time. Okay. Among other things, it emphasized that AFDC scheduled the visits in advance. The visits were conducted by non-uniformed personnel, a caseworker who was not a sleuth, but rather a friend to one in need. And the visit was not a criminal investigation, although there was always a possibility of discovering evidence of a crime, which is a routine and expected fact of life, right? So if they go in and they find drugs sitting on the table, right, or something like an open drawer and they can see pills that are like, some sort of illegal pill, then yeah, there's criminal activity. But they didn't go there originally with the expectation of finding criminal activity. They were going there to check on the well-being of the child and making sure that the money was spent on the child in an appropriate manner and way. Okay. The court concluded that the home visit was a reasonable administrative tool and not an unwarranted invasion of personal privacy. So in that instance, Bottom line, they are allowed to search without a warrant because they gave them a heads up as to when they were coming. The government gives a check to these, parents that don't have enough money to take care of a child. And in order for them to keep the checks, they have to allow for, DCF type individuals, or in this case, AFDC individuals, to come and check on the child. So they said, okay, that's fine. 35 years later, we addressed a similar issue in Sanchez. So this is the second case that they looked at. Under California's welfare program, applicants must submit to a visit from the Public Assistance Fraud Division. So in this case, instead of talking about a child situation, we're talking about a fraud situation. If they're receiving welfare benefits, are they truly in a state of poverty and need them? Or are they committing fraud by trying to get a little extra money? Okay. So here we go. So the Public Assistance Fraud Division of the District Attorney's Office would go ahead and verify that there's an eligible child in the household and that an absent parent does not live in the home. They would check to see if there's fraud. Actually, yes, so my apologies. This does include a child situation. Although the PAFD did not tell the applicants the exact date and time, it would advise them generally of the visit, which typically lasted 15 minutes to 1 hour and included an applicant-led walkthrough of the premises. Okay. Closely following, so this is not a poverty thing. This is a child thing again. My apologies. Keep in mind, I read this 4 weeks ago, so I'm just giving you a heads up. Closely following Wyman, we reached two conclusions. First, we held that these visits with this Sanchez claim were not searches within the meaning of the Fourth Amendment, noting that Wyman's reasoning on the question of whether the home visits are searches under the Fourth Amendment arguably has been called into question by the Supreme Court's subsequent Fourth Amendment jurisprudence, but holding that Wyman was controlling because of its direct application. All right, so they're just arguing which case is more important here out of the two that are proffered, the Wyman or the Sanchez case. Okay. All right, so we noted that as in Wyman, the first case we talked about here, the home visits are conducted with the applicant's consent. All right, the person knows that you're coming. They're okay with you coming. They want you to come so that you keep paying them their check to take care of the child. Okay. And if consent is denied, the visit will not occur. And there's no penalty for refusing the consent to the home visit other than the denial of the welfare-based benefits, right? The child health benefits. Okay, cool. Alternatively, we held that even if the visits constitute searches, they were reasonable because the home visits serve an important governmental interest, making sure the kid doesn't die from not getting enough food, and are not criminal investigations. They don't expect to find criminal stuff in the house. I mean, look, if they find a crack pipe, then, it's not surprising that they might come across something like that, but there's no expectation that they're going to find a crack pipe. The expectation is they're going to get a walk through the house, see that the child's doing okay, and then continue forward. That there are not criminal investigations occurring, and the applicant is in knowledge of, with advance notice and consent, of basically their visit. And this will alleviate the serious administrative difficulties associated with welfare eligibility verification, right? Because otherwise, how do you verify that these people are poor, other than to do a visit, right? We hold that these home visits are reasonable on the Supreme Court's decision in Wyman. So basically, they said, okay, if there's a kid involved and they got to check on the kid and they tell them ahead of time they're going to come check on the kid and do a walk through the house, that is considered not a search under the Fourth Amendment, which means that a warrant would have to be issued. Okay, cool. All right. Okay, so then we go to this over here. Hold on. I did not staple this well, by the way. Let me go over here. Okay. Wyman and Sanchez do not support the ruse visits conducted by CDIU. So those two cases we just talked about, Wyman and Sanchez, they don't support this whole ruse visit situation. In those cases, there was no search of a home within the meaning of the Fourth Amendment because there was no physical intrusion into the home without the homeowner's consent, which they gave ahead of time. And two, the visits were a condition of eligibility for benefits. Whereas this, the person gets the benefits, but is not required to have a search in order to keep them, which I'd like to take a moment to point out aside from this. What the SSA could do in the future is require, as a disabled person or somebody specifically on SSI, who's on SSI disability benefits, what the SSA could do is they could go ahead and require of people receiving SSI benefits home searches every so often. So that's something that could potentially be on the table. And the reason why is there's a lot of people on SSI benefits who use that money from the federal treasury to buy drugs from, obviously, drug dealers. Okay. So basically, considering the officer's purpose for entering a constitutionally protected area without an express invitation to determine whether conduct complied with an implied license or was an unlicensed search, right? So they're looking at here, okay, was the search licensed? Did the person give the okay? Was it something under duress where if they, didn't give it, something criminal would happen, they go to jail? Or was it just one of those things where if they didn't do the search, they would lose their benefits? Okay. Home visits, the home visits were transparent for both of those kid claims. Both sides knew what was at stake and why the caseworker or investigator was in the home. So those two kid claims, right, they made sense. But in this situation, for the disabled person, it's different because they didn't know what was at stake because the officer lied to them about what the officer was doing, right? If the officer had said, hey, here's my badge, here's who I am, I'm here to investigate if you are the disabled person that what you claim you are. Your first thing to do is say, get off my porch, get off my property. You do not have a right to be here, because they don't have a right under disability to go ahead and search your home and do all those things. Right? With the kid situation, they're protecting a child that they're paying money to the parent to take care of that child. But with the disability situation, there's no child. You receive those benefits because you, for the most part, can't work. And as a result of that, if they send somebody over and that officer lies to you, then you didn't have clearly in your head as to why that officer was there. And as a result of that, you letting them in when the officer lied to you, unconstitutional. Let's keep reading. The present case is distinguishable on both grounds. Benefit applicants and beneficiaries in Wyman and Sanchez were informed that a home visit was a condition of receiving benefits, and they were given the option to consent or refuse entry. The claimant in this case was given no notice that a home visit would be conducted in connection with her benefit claim, because a home visit is not a condition of receiving disability benefits. But don't think the government won't try that in the future. Okay. That's something the Republicans will probably push. All disability beneficiaries will have to have a home visit to see if they're still the disabled person at which they claim they are. Which then gets into the tricky situation of, well, how the hell would somebody, unless they're a doctor, know if that person was disabled for their particular issue? You'd have to literally send specialists for that person's particular impairment to that person's home with an officer to do like an at-home visit. Or what they could do in the future is make you periodically go to their DDS, ME medical expert appointments, which is just not as effective as going and raiding your house. But, bottom line is they already do that at some point with CDRs. They'll send out a CDR notification. They'll set up a CE, consultative examination, medical expert. Their doctor will review you. But the next step beyond that is they raid your house. So that could be a future thing. Now, the disabled person had no opportunity to consent to or refuse the visit from the cop. Of course, as McMullen testified, the subject of an investigation could refuse to speak with him or refuse him entry at the door. But in this scenario, the subject would believe she was refusing to assist a law enforcement officer in the investigation of a crime. She would have no idea of any connection to or potential effect on her application for benefits. So when that cop rolled up on this disabled person, she didn't know that he was there to investigate her. She didn't know that that investigation was related to her disability benefits. She was trying to help this police officer find, fraud related to theft of identity. In fact, the disabled person went and got the information of a person that she believed was actually stealing the identity of somebody else. So once again, those who are the most patriotic get screwed over by the police here. That's the unfortunate thing. Okay. Once we add to this fact that McMullen, the officer, videotaped his entire visit, one of the cameras failed partway, any illusion that this was not a Fourth Amendment search evaporates. And remember, if there's a Fourth Amendment search, you need a warrant, unless they're chasing after a probable cause situation. McMullen has two cameras running while he was talking with Whalen, and at least one of the cameras captured his entire visit inside her home. Of course, it was a search. Not only was McMullen there to observe Whalen, but he had also been asked specifically to seek evidence concerning Whalen's use of an electric wheelchair. how wheelchair accessible the house was. Could the electric wheelchair get in? Could it get out? Okay. Were the wheelchairs used? Were there indents and pushes and this and that, and were the wheels starting to rust? Yada yada. Were clothing or other things being stored on them? Okay. McMullen's report faithfully fulfilled his charge from CDIU. He reported that the wheelchair was being used as a blanket holder and that the arms of the chair were not creased or indented from frequent use. This evidence could only have been obtained inside Whalen's house because the officer couldn't see the wheelchair from the doorway when she opened the door. This evidence could only have been obtained inside Whalen's house, and McMullen secured it through an unconsented, warrantless search. Now, I am going to say this to you. If you have an ambulatory device and you are worried that it looks brand new and you have no proof that you just bought it, I would not be surprised, although I cannot advise it, but I would not be surprised if you put a book on each armrest to show indents on them and use sandpaper on the chair to rough it up a bit so that if you were ever searched, you would not be caught with a new wheelchair that you couldn't prove that you purchased or recently obtained, but rather, if the cop or the investigator were to say, hey, looks like that's a brand new wheelchair, like you don't really use it that much. What proof do you have that you do use it? Something to consider. As for the purpose of this, while the visits in Wyman and Sanchez, those two prior claims with the kids in them, both rehabilitative and investigative in nature, Wyman at 400 US and involved looking for when they put citations in their sentences, it's so hard to read them because it's just like sentence and then massive citation, and then somewhere like two sentences down is like the rest of the sentence. They were involved looking for inconsistencies between the prospective beneficiary's application and her actual living conditions. Their underlying purpose was the determination of welfare eligibility, not like the case we're looking at, which is disability, how severe the person is. In Sanchez, PAFD required all welfare applicants who were not suspected of fraud or ineligibility to undergo a home visit. Although the investigators were required to report evidence of potential criminal wrongdoing, including welfare fraud, for further investigation and prosecution, the home visits were not fraud investigations. Okay, remember, with all these disability CDI unit situations, they're looking for fraud. Now, I was yelled at by a couple of the viewers when it comes to what the level of fraud is. And the viewers of this channel, some of them had a very incorrect understanding as to what the level of fraud actually was. It is not where you are a CEO of a major bank making millions and still getting a disability check. While that is fraud, that is not the standard of fraud that they're looking for. The standard of fraud that they are looking for is where you claim that you need a wheelchair, and yet another report said that you arrived at some facility and did not use a wheelchair during that visit. That is the standard of fraud. Okay. All right. The CDIU does not investigate all benefit applicants, only those whose claims have been referred by DDS for suspected fraud. Oof. Actually, okay, so right here, the court got that sentence incorrect. CDI units, they don't just get referred claims by DDS. Sometimes they get referred claims from OIG's website, the commissioner of the SSA, referrals specifically from politicians, referrals from police. Ultimately, they do end up around DDS, but it is actually OIG that's the real pin there for holding together the CDI units and their interaction with DDS. So it's more than just DDS. DDS isn't the only one that just refers them over. Okay. The Washington State Patrol Officer, that's cool. We found something wrong with this. The Washington State Patrol officers assigned to CDIU who conduct the investigations have law enforcement powers, and their duties and responsibilities include using their existing arrest authority granted under the laws of Washington. So what we're saying here is cops, sheriffs, marshals, people with the authority to arrest you are hired to go and investigate you when you're disabled and they think there might be a little bit of fraud in your statements, okay, whether it's a little bit or a lot, okay? All right. While CDIU reports the investigation results to DDS to facilitate timely and accurate disability eligibility determination. CDIU itself, the CDIU and its group, right, the people who hire the people to come knock on your door, CDIU itself is prohibited from making recommendations and providing opinions regarding disability eligibility. Because let's call it like it is. An officer of the law has no idea whether or not you're severely impaired. They just don't know. Right? They're not doctors. They're not vocational experts. They just don't know. Okay? Even though CDIU investigations may not lead to criminal prosecution, other agencies may use the investigations to determine benefit eligibility. This situation is materially different from those in Wyman and Sanchez, in which home visits were an express condition of receiving benefits for all applicants. So what they're saying there is a condition of receiving welfare benefits when you've got a young child and you need money to take care of that kid is that you have to have home visits done. But a condition of disability benefits is not that in the future you will have home visits so they can see if you are still severely impaired. Or for SSI, severely impaired and poor. So, but like I said, don't expect the Republicans to not do that. That's something that I'm sure they'll come out with. And that's one of the things I like about this channel. We make fun of and disgrace the Republicans and Democrats equally. We equally go after both parties and make them look like total shitsters. And that's the bottom line. If you, and sometimes I get messages, I get voicemails from screaming people at the law firm about how I said something about their little boo-boo, their little Biden, or their little snuggle, their little Trump, and they lose their shit. They lose it on the phone. But I'm used to it now, and it doesn't really bother me because, you know, they just don't have the money to travel 17 states over. Just kidding. Just kidding. It's only 5. All right. So with that said, that's because that would put you all the way in, like, you know, Alaska, you know, and then you'd have to take one hell of a route. But anyway, the point is, remember, guys, these are your rights. You do not want the SSA getting the right to investigate you and do home visits for you to receive disability benefits. You are not required to have home visits. You are required to partake in the process of, you know, whether or not you're still disabled, maybe go to their doctor, fill out a form to see if you're still disabled, go through the 8-step sequential process, but you are not required to have somebody show up at your door to investigate whether or not you are still severely impaired and or poor if you're on SSI benefits. Okay. So even though CDI unit investigations may not lead to criminal prosecution, other agencies may use the investigations to determine benefit eligibility. Now, McMullen's declaration that he does not enter a person's home in order to conduct a search of the residence, but rather, so this is what the cop is saying. This is the cop's defense that he's asserting. The police officer's declaration that he does not enter a person's home in order to conduct a search of the residence, but rather to obtain information regarding their physical, mental, and emotional faculties / responses, and that he did not actually conduct a search of Miss Wallen or her home, does not alter the court's analysis. So what they're saying is, just because the officer said he didn't conduct, it was his word as an officer that he didn't conduct a search, doesn't mean that the court is swaying in that direction. Okay. Let's see what they've got here. Okay. McMullen's purpose was, so here's where they basically hang the police officer out to dry, which, you know, is very appropriate in this instance because it was very unconstitutional. So McMullen relied on the evidence for the fraud investigation, which he did by making observations with his cameras, 2 cameras, and video recordings of Wallen and her home. Because he entered the home while using a ruse, lying to the disabled person, and not while undercover, he had his badge and everything. It is immaterial that he stayed within Wallen's presence in the home and did not conduct a broader search. So what they're saying here is he went into the home and had all this camera footage, and it's obviously a search because he got the evidence from going into her home while doing a search-based investigation on fraud. He says, no, it wasn't a search. The court's like, I'm not having any of that shit. Not having any of that shit. This patrol officer obviously committed a search. He did not have consent to be in the home for the purposes of his visit. And he did not have consent under any terms to videotape Whalen or her home. By observing and videotaping Whalen inside her home without her consent, McMullen conducted a search within the meaning of the Fourth Amendment, which means he would have needed to, A, get a warrant, or B, have been concealed and not, have told her that, he was a police officer or patrol officer or whatever. Okay. When it comes to the Fourth Amendment, the home is the first among equals. The home occupies a special place in the pantheon of constitutional rights. They looked at the reasonableness. Whether a particular search meets the reasonableness standard is judged by balancing its intrusion on the individual's Fourth Amendment interest against its promotion of legitimate government interests. Okay. It is a basic principle of the Fourth Amendment law that searches and seizures inside a home without a warrant are presumptively unreasonable. Okay. So automatically we think, you search a home, you don't have a warrant, it's presumptively unreasonable. The side that did the search has to prove that they did the search in a legal way. They have to come up and show that they did a legal search before anything from that search is going to be allowed in. Okay, reasonableness under Wyman and Sanchez, those two cases we talked about with the kids. As in Wyman and Sanchez, CDIU investigations serve the important interest of preventing benefit fraud and may aid in the verification of claimants' eligibility for benefits. Like I said, expect Republicans in a vote near you to require disabled people to have home searches in the future. But they differ in other material aspects or material respects, because the home visits at issue in Wyman and Sanchez were required for every welfare applicant. A warrant requirement would pose serious administrative difficulties because to get a warrant for every mom that has a kid, that's a lot of people. And that's just it's not going to happen. Like the legal system, you'd have to have a lineup of judges just constantly signing them, which, they have to do analysis. They have to take the time. If no probable cause existed that an applicant had violated a law, no warrant could be obtained for a home visit for that applicant, right? So what they're saying with the whole child situation, they don't have any evidence that the child's being abused, the money's not being spent on them, then how are they going to get a warrant? There's no way, right? They're not going to get a warrant. They won't get entry. So they make it a part of that system where they get to search the home, and do a walkthrough with the parent to receive these welfare benefits to take care of the child. Where a warrant could be obtained, it presumably could be applied for ex parte. Its execution would require no notice. It would justify entry by force, and its hours for execution would not be so limited as those prescribed for home visitation with those kid situations. Okay. Now, with that said, a warrant requirement would accordingly make home visits more intrusive than the suspicionless home visit program, because welfare applicants' rights and privacy would be subject to greater infringement. So instead of the non-officer, like there's no badges on them, it's just a caseworker, right? For these kid claims, caseworker comes in, goes through the house, they go through a walkthrough. The caseworker isn't pulling out drawers, flipping them over, and finding condoms and finding drugs and finding guns. They're just doing a walk through the house. Okay. As discussed above, CDIU investigates only those claimants suspected of fraud. And the investigations are done on the understanding that if fraud is discovered, there may be civil or criminal consequences. Civil, they take away money from you or benefits, and criminal consequences, they put you in jail and potentially take away money and benefits from you. Okay. Given that the CDIU purportedly obtains warrants in some investigations, which are usually the criminal ones, a warrant requirement would not appear to be present to present the same administrative difficulties in this context, right? Because they don't have to do a home search of every disabled person. They would just have to do a home search of those they suspected of committing fraud, right? Weighing these factors against the significant privacy and property interests implicated by a search of one's home, we cannot conclude, here's the important sentence, we cannot conclude that the CDIU ruse investigation in this case was reasonable under the Wyman and Sanchez Supreme Court cases. Reasonableness under the special needs warrant exception. All right, so now this is where the court goes through this special warrant exception. I'll let the description kind of explain it, and then I'll give you a quick walkthrough as to how it applies. McMullen also argues the special needs exception may apply to the civil investigation. There is a special needs exception to the warrant requirement for administrative searches, such as searches of probationers' homes, drug testing in public schools, and inspection of regulated businesses. So this is an exception where they can do searches and they don't need a warrant. These are the things where they don't need a warrant to search. Okay, so just think of it that way. To determine whether a warrantless search falls within the special needs exception, we, number one, determine whether the government has articulated a valid special need, right? If we're searching to make sure kids are safe, that's a great example of a special need. If we're searching to basically go into a business that handles, let's say, heavy weaponry with like special chemicals, or the new thing, which is of course the horrible thing, which is, weaponry through funguses, viruses, bacterias, things like that, which, obviously we know what's going on with problems there, then that would be a special need where the government can search the facility more at will, okay? Or at least give them notice, things like that, depending on the need of them to get in there and make sure everything's okay. And then element 2, analyze whether the proposed administrative search is justified in light of that articulated special need. Okay, so how much of a reduction of the rights of that business or that person should be allowed because of how scary and terrible it would be if we didn't search them? Like, would a child die as a result of us not searching this house? Would there be a massive chemical war if we did not search this place and find nuclear waste not being properly kept, right? That's what they're looking for. How extreme is our need to figure out what's going on here? A special need must be beyond the normal need for law enforcement, okay? And thus, a valid special need for an administrative search must be distinguished from general law enforcement purposes. The CDIU internally distinguishes between those investigations that are for potential criminal prosecution and those in which only civil or administrative penalties may be sought, even though the nature of an investigation can change. So put another way, if it's a criminal investigation where they think they've got really good evidence to show criminal conduct, they're going to get a warrant. If it doesn't look like criminal conduct, it just looks like some civil stuff or some administrative stuff, then they won't get usually a warrant. Okay. All right. Now, with that said, it is not disputed in this case that McMullen's warrantless entry, the cop's entry into the disabled person's home, would have been an unreasonable search had this been a criminal investigation. But Fourth Amendment protections apply in civil investigations, as well as criminal investigations. And the Supreme Court has expressly rejected a distinction between the two for purposes of Fourth Amendment protection. That was in Kamara v. Munn. What you need to know is that they don't have a right to search your home unless they have a special exemption or rather exception. And that if it's a civil thing that they're trying to hit you with, a tort, or a criminal thing where it's a violation of some criminal statute or law or whatever, they apply the Fourth Amendment in the same way to both civil wrongs and criminal wrongs that you could be potentially committing. Okay. All right. Good. Holding that in the absence of an emergency, the administrative search of a residence under a fire, health, or housing code enforceable by criminal penalties is a Fourth Amendment search requiring consent of a warrant. Okay. Distinguishing Kamara and related cases on the ground that refusing to consent to a search led to criminal prosecution rather than the denial of benefits, we are not convinced it is appropriate to distinguish between CDIU's civil and criminal fraud investigations. But we would find that the search in the civil investigation in this case unreasonable, even if under a special needs analysis. What the court is saying is, hey, SSA, clean up your shit here. This is not okay for you to do a warrantless search where your person lies to the disabled person off of the honor of the police officer. Think about that for a moment. Just take a little consideration. Do you feel it's acceptable for a disabled person to rely on the honor afforded a police officer, a marshal, a sheriff, to rely on that honor, that they would be a trustworthy, directing person? Do you feel it's okay for a disabled person to rely on that and then get basically screwed over by that officer? It sends the wrong message. I think also realistically, people, to be fair, are not so ignorant to the abuses of the government. If you look back to Edward Snowden, if you look back to all these individuals who are saying, hey, look, you're being recorded outside no matter what you do. They have these special equipment that can basically hear all your conversations, that can basically record, in ways that you've never known. People are now aware that Big Brother is more involved with their, lives than ever before. But the question is, what evidence is usable in my land, which is the legal land of going to court and criminally holding somebody responsible, civilly holding somebody responsible, or administratively holding somebody responsible? Okay. As discussed above, the CDIU searches, unlike the home visits in Sanchez with the kid, right, are done specifically to investigate claimants suspected of fraud. So with the kid thing, they got to investigate all the people and do a home visit, make sure the kid's okay. But for these disability situations, they only have to look at the ones that have potential fraud, which is a much smaller number than the entire millions and millions of people on disability benefits. Okay. Noting that while there may be a fine line between verifying eligibility and investigating fraud, the record here supports that the visits are indeed used primarily for verification and prevention purposes, and that no home visit has ever resulted in a criminal prosecution for welfare fraud. Okay, so that's for the welfare fraud. Holding that drug testing was not justified under the special needs doctrine, where the purpose actually served by the searches is ultimately distinguishable from the general interest in crime control. Even where CDIU investigations are for potential civil penalties or ultimately result only in an advanced adjudication of a benefits claim, they primarily serve the purpose of policing the Social Security eligibility rules. CDI units, the people who investigate you, does not investigate all Social Security claimants, only those claimants that CDIU suspects of fraud. McMullen, the officer, searched Whalen's home without a warrant to gather evidence for an investigation of her potentially fraudulent application for benefits. Thus, even if this was an administrative search, it served general law enforcement purposes and not a special need. All right, let me summarize that. When it comes to disabled people, they do not want the police lying to them and then searching their home because you gave them an allowable entry. They do not want the police officer to say, hey, it's an allowable search because this person said I could enter their home. Well, you're only able to enter their home because you lied to them and they felt a civic duty to help a police officer, and that a police officer would be less likely to lie to them. For all those people out there who watch this video and say, how dare you go after the police officers and the patrol officers and the sheriffs and the marshals, I'm not going after them. I'm explaining that and here's the thing we haven't talked about with this yet. This was an established method on behalf of the Social Security Administration's Office of Inspector General when hiring state-based investigators that were almost always with a badge, right? They almost always were this situation of they were showing up as an officer, right? With some capacity to go ahead and investigate this person. So when you're sitting there saying hey, wait a minute, can they go ahead and search, my house and yada, yada? No, they're not supposed to be able to search it if they lie to you. Now, if they come there and they tell you with their badge on and they say, I am searching to see if you are truly disabled and committing fraud and blah, 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 and you give them entrance to your home, then they can go in. But if they lie to you and say that they are for a different reason, they're not allowed in your home if you give them entrance, right? They're not allowed to do that search of your home. I mean, they still might go in, but they're not allowed to use any evidence that they take from your home. Now, if they go ahead and, don't have a badge on, and, basically they buddy up with you and then you invite them in, then they're allowed to search your home. So that's why this is such a difficult situation, because there are times in which basically you can go ahead and be searched by these individuals, at least under these rules and regulations, and times where you can't. So I see, I'm just looking at some of the comments here. Gary Kutwoski, no, yeah, there are times when they can search your home and times where they can't. So bottom line is you have to know the difference. But in order to make it simple for you, If there's ever anybody that wants to enter your home that you don't know, like you're a disabled person and you don't really know this person, you met them maybe once or twice outside of your home and they're like, a new buddy or whatever, you don't let them into your house. That's it. As a disabled person, if they tell you they're a police officer, if they tell you that they're a sheriff, right? And and they're not going to pull this thing. They're not going to pull the ruse situation where they lie to you about it again because of this case law. But if they go ahead and tell you, hey, we're here to investigate you, and they don't have a warrant to get into your house, they're not getting in your house. You tell them no, thank you. I realize that some of you are very patriotic and you feel that you have nothing to hide. Sometimes they will still find something. Sometimes they will still find something. So it is your job to make sure that if they want to investigate your house and they don't have a warrant, that you say thank you, but no thank you. They can leave. Okay? Because your benefits are not dictated by a home visit with investigation. They're not. Okay? For the foregoing reasons, we conclude that McMullen's entry into Wallen's home without consent or a warrant in the course of a CDIU civil fraud investigation related to Wallen's benefit claim, her disability benefits, was an unreasonable search under the Fourth Amendment. Cool. Now, whether the violation was clearly established, here's the tricky part of, do we hold this officer liable for his actions of lying to the disabled person to get entrance to search her home? Like, do we punish this person or do we not? Do we punish this officer or no? This conclusion does not end our inquiry. To hold McMullen, the officer, personally liable under Section 1983, Whelan's right to be free from a search in this context must have been clearly established. To be clearly established, the contours of the right must be sufficiently clear that a reasonable official would understand that what he is doing violates that right. So the question is, did that officer know that what he was doing wrong violated that person's right? Violated, basically that person's Fourth Amendment constitutional right to privacy. The court said he didn't, which tells you where the SSA was at during 2012 when they were doing this, all the way up to 2018 when this claim finally flipped. What happened was the SSA created a culture of the police officers and the sheriffs where they could go out and basically get access to your home by lying to you with their badge on. Pretty bad, right? Pretty bad. And that this culture was acceptable because, and I quote here, did this officer, a reasonable officer, understand that what he was doing violated that right, the Fourth Amendment? The dispositive inquiry is whether it would be clear to a reasonable official that his conduct was unlawful in the situation he confronted. So would this officer, would this cop know? The Supreme Court has repeatedly told courts, and the Ninth Circuit in particular, Ninth Circuit, you're such a funny little group, not to define clearly established law at a high level of generality, right? Qualified immunity is no immunity at all if clearly established law can simply be defined as the right to be free from unreasonable searches and seizures. Although we conclude that McMullen's warrantless ruse entry, the cop's entry into her house by lying, into Wallen's home was an unreasonable search, we cannot say it was clearly established that his conduct in the context of a civil or administrative investigation related to determination of benefit eligibility was a search or was unreasonable. Wallen does not have to identify a controlling case finding a constitutional violation on the exact facts of her case for her asserted right to be clearly established, but she relies on a boss and other criminal ruse entry cases. All right, so what they're saying here is this. In order to hold that officer liable for doing this terrible thing, lying to the disabled person, gaining access to her house, using 2 cameras to record stuff, and then using that evidence to kick her off of disability benefits. In order for the officer to use that evidence, get away with all of that, and be in the clear, right? They're saying that, and in this instance, they don't allow this anymore. Just so you understand, they don't allow officers to lie to the disabled person, go into their house, and then collect all the evidence and use that evidence against the disabled person to remove their benefits down the line. They don't allow that anymore. They don't allow that anymore. Okay. They still allow them to enter your house, in the sense of if you agree to and you know what the purpose of them being there is, or, if it's a situation where they're undercover and you don't know who they are, if it's still within the state and federal requirements for undercover. But in this instance, if it's a police officer, somebody with a badge, and they lie to you about why they're there, anything you gain from inside that house, not admissible. Now, do we arrest? Do we civilly punish that police officer? They're saying no, because up to this point, there had never been a case like this. Now, normally in criminal law, when this happens, we're still like, yeah, we still got to punish the person because he did a bad thing. But when it's in, civil or criminal law and it's a police officer involved, right? When it's a sheriff or a patrol officer or a marshal, whatever, if there has not been case law on this up to that point, they have immunity because they just couldn't have known that what they were doing was wrong, which sucks because at the end of the day, this tells you that the Social Security Administration was very cool with sending officers to your house as officers, having them lie to you, and then collect information to kick you off of benefits. That's your Social Security Administration. McMullen knew he was conducting a civil investigation, not a criminal investigation, and that it was related to the disabled person's eligibility for Social Security benefits. Additionally, McMullen did not initially seek to enter Wallen's home, but rather to engage her in front of her house. Wallen limited her constitutional challenge to McMullen's actions once he crossed the threshold. As the district court noted, there was no authority requiring McMullen to retreat from Wallen's home as the conversation moved inside, nor was there authority clearly prescribed McMullen, the cop, McMullen's conduct in this situation. We agree that it would not have been clear to a reasonable officer that his conduct in the context of this civil investigation related to a determination of benefit eligibility was unlawful. And that's because, it was how they did it, and there was no rule against it or case law against it. So what they're saying here is, because there was no prior case law against it and the SSA was cool with doing it, and that's just how they did it, the right Wallen asserted, the disabled person asserted, was not clearly established. Right? The right that she would not have her rights violated when he entered her home. And McMullen, the officer, is entitled to qualified immunity from this suit. So we just did a huge case walkthrough. We've been on this for now an hour and 22 minutes. I'll summarize everything for you. If a police officer sent by the Office of Inspector General on behalf of DDS, who works for the SSA, to see if you are still disabled because they think there might be a slight little itty bit of fraud, right? The standard is very, very small. If they believe there's a potential for fraud, if it's at a big level, they'll usually get a warrant to enter your house. If it's at a small level, they'll usually do what's called, if it's like a civil level, like a tortious level, or like an administrative level. Thank you, Astros, for the $5 donation. Super appreciate it. It's awesome, awesome, good sir. Excellent, excellent. So basically what you need to know is this. If that officer comes up to you, is currently in officer duty robes, right? Lies to you in order to get entry to your home, and then captures a bunch of footage of them in your home and uses that to kick you off of disability benefits, then that is considered to be unconstitutional. And this particular officer did not get in trouble for doing it, but every single police, cop, sheriff, marshal, whatever after this case would be held liable, would get in trouble. Potential financial trouble, removing of their ability to be a police officer going forward, removing of their badge, removing of their firearm, potentially criminal investigation into them, things like that. That would be a situation where every officer going forward trying to do this would be punished. Okay? Because now it is established in this case, even if the case in the future is a little bit different, as long as it's somewhat linear with this fact pattern, as long as there's consistency that are legal doctrines at issue, future officers will be punished for doing this conduct. This is a big video. I hope you enjoyed it. I have to go and basically work next door on that house. Anyways, I hope you're doing well. I'm going to look and see if there are any questions here real quick. Let's see. Kylie Ray said, because being disabled and poor isn't bad enough, we have to deal with this kind of shit. You're right. I mean, it sucks, but there's a lot of people also abusing Social Security disability benefits and retirement benefits. So one of the problems you run into is essentially that because there's so many people abusing these benefits, you're going to run into the program trying to save money. And remember, they're saving millions and millions and millions of dollars each year by not having to pay out benefits to those people that they've kicked off the program. Some of them, validly so, were kicked off the program because they were committing true fraud. Okay, Adam Brock said, sorry, breaking laws doesn't mean they deserve treatment like that. Ate alive by the bed bugs. Okay, got you. Yeah, I mean, it's, yeah. So April Galton, thank you for the $5 donation. Really appreciate it. I hope you guys enjoyed this video. And the reason why is understanding exactly where the line is as a disabled person is crucial, because there's going to be a moment in maybe 1/1000th of you that actually view this video, right? 1 in 1,000 people where this happens to you and you're sitting there and you're like, do I let this police officer into my home? No, you do not let them into your home unless they have a warrant. That's it. Unless they have a warrant. That's it. That's it. If there's a cop chasing after somebody and that person breaks into your house and runs through your house and the cop is following it, that's different, right? But in this instance, you don't let them in. And also, if there's somebody new that you met that you just really get along with, you know, like the way I like to describe it is like when a guy goes to a bar, or let me get this thing out of the way. When a guy goes into a bar and he's really getting along with that female at the bar, boy, he's getting along with her, and she turns out to be an undercover detective. I mean, like you knew to some degree that person, you were just getting along so well. And that's because the person that you're interacting with is hyper capable of manipulating you. Similarly, if you've met a new friend and then 2 weeks later you're inviting them into your house, as a disabled person, please be very careful, because it could be a police officer. It could be. Okay. And remember too, and I think this is important, police officers come in all sizes and shapes. There are 6'7" police officers that are super chubby. There are 5'1" police officers that are super muscular. There are all kinds of people that are police officers, all kinds of people that are and remember something too, and I think this is important. A lot of people expect police officers to be fit because it's part of the regiment they have to work out. But remember, those police officers are required as part of their investigation sometimes to put on weight, to get heavier so as to match the expectations of what that person's trying to do when it comes to misleading people in their little circle. So I just want you to keep in mind that this is how it works. I want you to understand what to watch out for. And, you just remember, a lot of people not watching this channel have no idea. They don't know that if, somebody sees your wheelchair and your wheelchair looks very new and you don't have any proof that you just bought it or somebody just gave it to you or whatever, and that their expectation is that you've had this wheelchair and this wheelchair doesn't look used, even though you're required or you're claiming that you used it all the time, that they can use that against you to kick you off the disability benefits. Like, people don't realize how small and little nichey that thing is to make you lose your payment that you require to be able to survive and eat food on a daily basis. So anyways, let's see. David Gray said, I agree with Adam Brock. Adam Brock said, everyone deserves a way to live no matter. Man-made problems has made many, many, many more issues. Foxy Dog Itchy Paws said, great advice. Sen McGuire, very cool. I've met undercover officers that looked like they were in ZZ Top. You never know. Thank you for the $4.99 donation. I really appreciate that. One thing that I think is interesting for me is that because I'm a Mason, although I'm one of the shittiest ones out there because I never go to lodge, I literally just pay my yearly dues and just don't do anything. But I've met a lot of, there's a lot of sheriffs, officers, stuff like that in the Masons, and you meet all kinds of people. And when they are undercover, they look the part. Like if they're going to like a metal band thing to see what's going on with drug abuse or something, they've got the boots on, they've got the hair right, they've got the fingernails right, they've got the tattoos right. It's just, they got it. They got it right, So anyways, Hannah Track said, why do you think they want your guns? Sonia Blade said, Walter, your videos have helped me. I just applied for disability and your videos have helped. Awesome. Gary Kotowski, I got so much advice from your videos as I have to learn the CFR entirely basically for my CDR. I mean, you don't have to learn the entire CFR for the CDR, but there's a lot of good stuff in it that you should know. You really should, but that's good. I'm glad you're learning it. John said we're experiencing a genocide. Hannah, Kylie Ray did little quotations, and Senator McQuire said smash the like. Yes, also, I'm bad at YouTube, even though I'm the most viewed and subscribed to disability attorney out there. Please remember to like. I have a sticky, but it fell down. I'm supposed to do a couple of things. Those things are, number one, please remember to like. Number two, please remember to subscribe, hit the bell. Number three, please remember to leave 5-star reviews. I love seeing those 5-star reviews because I wake up usually on Monday. I'm like, cool, look at that. But the point is, you go to Google, you type in disability resolution law firm into Google, and then you look to the right side where it says leave a review for this company. If you like these videos, please leave a review, a 5-star review. The other thing is I'm supposed to always ask you a question to have you interact with the video. That's a thing with the whole YouTube video. So here's my question to you. Do you think the court system should go back and re-review those cases from prior to 2018 and some of 2018 where ruse tactics were used potentially but not adjudicated that cost people their benefits? Do you think that we should go back and look at all those cases and then re-adjudicate them to see if that person validly lost their benefits as a result of fraud, or whether they lost their benefits due to evidence that should have never been allowed to be used? Should we go back and correct that? Because remember, if this is the case of first impression, if this is it, think about all the ones that never made it to court, where they used a ruse and they didn't get an attorney to go ahead and file a lawsuit against the officer. What do you think? Anyways, guys, I will catch you a little bit later. Have a wonderful night, and please stay safe. Enjoy your Sunday, and we'll go from there. Thanks so much, guys. Bye-bye, guys. Bye-bye.